Hello and welcome to this brief overview of the Comparative Contract Law module. The aim of this video is to provide you with information about the Comparative Contract Law module, which I believe is vital for your decision as to whether you'd benefit from taking this module or not. Now, you'll find that there are two aspects to the Comparative Contract Law course. The first is comparative law as a discipline, how we compare, what we can expect from comparison, and how it might help us better understand our own laws more generally. Now, we'll soon find that comparative contract law is not about setting out the law in two jurisdictions side by side, but that instead we can compare across time, disciplines, doctrines, as much as we can also compare, of course, across jurisdictions. And the second aspect is a substantive comparison of laws. We'll focus on a few key doctrines of law in a number of jurisdictions. For example, we'll look at pre-contractual relations, the law of mistake, the law of frustration, and remedies. So what I believe we should do next is to set out what the aims of the module are, the expectations we have of you before you even begin, the assessment, and how the module will operate in practice. So what are the aims of the module? Well, there's quite a number of aims. The first is that we're going to try and appreciate the techniques required for an effective comparison. That means that we're going to look at how and what we can actually compare to make it a real comparison. We'll notice that comparing oranges and elephants, for example, may in some cases work, but in other cases deliver really false results. And so with that, we'll also understand what can and can't be compared. And that's really important for looking at other work, for example, in the field, where we can then evaluate, critically evaluate, whether it's actually a comparison that proves the results, or whether, due to the techniques used, it's actually a false result. We're trying to identify diverging theoretical and practical approaches. And that's quite important because we'll start asking whether different jurisdictions or doctrines or the history, when they deliver diverging results, are doing so accidentally or deliberately. And if they are deliberate, then why is that so? And that's something we'll be spending quite a lot of time on in this course. We'll develop a deeper understanding of key doctrines of the law of contract across jurisdictions. That's because we're going to spend time looking at these key doctrines. And the more we delve into doctrines that are not our own, the better we'll understand how our own doctrines work in our home jurisdiction. And then with all the support, and I'll talk about this a little bit later, we'll develop your legal writing skills. So you'll get one-to-one support with your writing skills. So then we need to have a look at what are our expectations of you before you start the course, because there are some requirements that I suggest are important, because otherwise you're going to spend a lot of time trying to catch up. The first expectation is that you have an appreciation of and an interest in underlying theories of contract law. Why do we make promises? Why do we enforce promises in society? And I'd recommend that you really have engaged with this before you start the module. We'd also expect basic knowledge of the main legal doctrines in English contract law: formation, mistake, misrepresentation, the kind of remedies that are available, and so on and so forth. You will really need to want to read a significant volume of literature. Because we're looking at various jurisdictions and we're looking at various theories, there's going to be a lot of reading that you're going to have to do, and you're going to have to do in your own time in preparation for workshops. The workshops will be quite intense in delving beyond the literature. And finally, because it is your topic, we'll come to that in a moment, and because a lot of it's based on your own reading, you really need to bring a willingness to identify your own learning needs. What do I need to develop my own understanding of this topic? And then we can give you feedback on that. Now, feedback is, of course, an important aspect of this course, so that's probably something we should talk about next. The assessment is a 3,000-word essay. The topic will be your own choice. But choosing your own topic is actually quite difficult. And part of the module is going to be about how you identify what the right kind of topic and what the right kind of question is for what you want to find out. Now, you're not on your own with this, you'll get a lot of support. So let me talk about how we're going to do that. Well, first of all, in the workshops, we're going to develop an understanding of the key theories of comparative and contract law. That means we're going to ask, why does comparative law do this? Why does comparative law expect this? And how does that mesh then with why contract law works the way it does? Then in the next set of workshops, we'll help you identify relevant topics. Now, we're not going to tell you what to research or what to look at. That's very much down to you. The workshops will be there to identify what you're interested in. What do you want to do in this area? What are the burning questions you want to answer? And how can you go about that? So the workshops are very much built around that. You will then have one-to-one feedback sessions to help you identify further relevant material. So you will come with us with an idea, and we'll provide you with some initial reading that can get you onto the right track. We'll also discuss the topic with you and make sure that you know where you're going. And finally, you'll be able to submit your essay plans for one-to-one feedback. So you get written feedback and one-to-one, personal feedback on your essay plans to help you develop. That was then a brief introduction to the comparative contract law module. If you have any other questions, please don't hesitate to contact me and to ask me any of the kind of questions you think would be relevant. Please remember, we expect a lot of reading on this module. It will be quite theoretical. And you really need to have basic understanding of contract law. Thank you very much for your time. I hope I can look forward to seeing you on the comparative contract law module.